Hey there, legal eagles. Today we're diving into a concept that has caused quite a stir throughout American history: nullification. In the simplest terms, nullification is like a state government saying, nope, we're not doing that. When it comes to a federal law, imagine the federal government passes a law that all states must follow. Nullification is when a state decides they disagree with that law and refuses to enforce it within their borders. Think of it like a big game of constitutional tug-of-war between state and federal power. It's a controversial idea that goes straight to the heart of how power is divided in the United States. Buckle up, because things are about to get historically interesting.
Nullification isn't just some abstract legal theory, it's been tried before. One of the earliest and most famous examples involves the Tariff of Abominations in 1828. Southern states, especially South Carolina, felt this tariff on imported goods unfairly favored northern industries. They argued it was unconstitutional and threatened to nullify it. Talk about a constitutional crisis. Fast forward to the mid-20th century and the civil rights movement. Some southern states attempted to use nullification to resist federal laws desegregating schools and public facilities. They argued that states had the right to maintain their own laws, even if it meant going against federal mandates. These examples show how nullification has been used throughout history as a tool for states to challenge federal authority on issues they felt strongly about. But could states really just ignore federal laws they didn't like? Well, the courts had something to say about that. The Supreme Court, the big kahuna of the judicial branch, has weighed in on nullification a few times, and their decisions have shaped how we understand this concept today. One of the most important cases is McCulloch v. Maryland in 1819. While not directly about nullification, the court's decision established the principle of implied powers, strengthening the federal government's authority over the states. Then came the big one, the nullification crisis of 1832 to 33. President Andrew Jackson stood firm, asserting the supremacy of federal law and threatening to use force against South Carolina. A compromise was eventually reached, but the crisis solidified the idea that states couldn't simply nullify federal laws they disliked. The Supreme Court continued to affirm the supremacy of federal law in cases like Cooper v. Aaron in 1958, reinforcing the idea that states can't simply disregard federal laws they disagree with. So, where does nullification stand today? While some groups still advocate for it, the legal precedent is clear. States can't simply nullify federal law. The Supreme Court has repeatedly affirmed the supremacy of federal law, and the Civil War settled the question of whether states can secede from the Union. However, the idea of states' rights and the balance of power between state and federal governments remains a topic of debate. While outright nullification might be a relic of the past, the tension between state and federal authority continues to shape American politics and law. That's nullification in a nutshell. It's a complex issue with a fascinating history, and it reminds us that the balance of power in a federal system is always evolving.